All right, we have one last case on the docket this morning, OMNI Healthcare, Inc. versus RUIZ.
May it please the court, my name is Michael Riemenschneider and I represent OMNI Healthcare. The first issue that I wanted to touch upon was the liquidated damages clause that was found by the court to be an unenforceable penalty pursuant to the Lefamine versus Barron case. In that particular instance, we argued that although Lefamine versus Barron is mandatory authority, it was a case that we felt the language of the contract itself really was different from the language found in the Lefamine case, which was really a kind of a simple real estate contract. This was a contract involving a doctor employee, had been with the company for...
Isn't the issue whether it's an exclusive remedy?
I think that the question is if it's the exclusive remedy. I think it boils down to whether Section 27, the remedies cumulative provision of the contract, provided an option that was available to the parties in that particular case. And then it was a situation where the court found that it wasn't an exclusive remedy and therefore found that the liquidated damages clause was an unenforceable penalty. The argument we made below was that the contract itself seemed to have certain provisions in it that seemed to appear to provide that the court should have construed the contract in such a way as to preserve Section 8, which was the liquidated damages clause and the covenant not to compete clause. So we argued that those provisions that were found in Section 8 and as well as the severability clause, that the intent of the parties was clearly that the drafter intended the remedial scheme of the contract to be a liquidated damages scheme and not something that was required to be an actual damages.
But if a severability clause fixes the problem, it makes it really illusory, doesn't it?
Well, I don't think it makes it illusory. I think that you take a provision, this provision, Section 27, which apparently doesn't have any use other than to provide a problem for Section 8. I think if you look at the contract as a whole and construe it as a whole, then instead of isolating on one particular provision, I think that the intent of the case or the intent of the contract was to preserve Section 8 and that Section 27 was not something that was to undo the entire scheme of the contract, the remedial scheme of the contract.
So what was the purpose of 27 then?
It appears to, it's obviously a remedies cumulative provision. It allows the remedy to be, of liquidated damages to be accumulated with a potential at-law remedy as well as another remedy which may be specific performance or injunctive relief. I don't think that the intent of the document, as I've stated, was that the parties wanted to have Section 27 undo the entire remedial scheme of the contract, which was what was agreed to, what the parties had negotiated for. So I think that Section 27 is really kind of an aberrant provision that should not be focused on as an indication of what the intent of the contract was. The intent of the contract was such that Section 8 was to be preserved. That was our position.
Just so I understand.
Yes, sir.
If the severability clause was not in the contract, do you think that paragraph 27 in conjunction with the liquidated damages clause is a problem, or do you think even without considering whether we can sever it out, that it doesn't create a problem with the Supreme Court precedent?
I think that there's an inconsistency. If you take the severability clause out and you just look at Section 8 versus Section 27, I think that there's an inconsistency there. And that inconsistency ultimately should provide for a construction of the contract and what the intent was. So I think there is a problem, the tension between Section 27 and Section 8.
Did you argue below that the contract was ambiguous?
I argued in record citations 446 and 447 that at the summary judgment hearing that the provisions were inconsistent with one another and needed to have judicial construction. Yes, I did argue that, sir.
And who drafted the contract? Was there any discussion over against whom it would be construed?
Well, there was a provision in the agreement itself, in the boilerplate, that said, no matter, despite who drafted this agreement, and it was drafted by the attorney for OMNI, but despite that particular drafting by that lawyer, this provision, I think it might be paragraph 25 or section 25 of the agreement, says that you should not construe the agreement one way or the other. There was actual provision in actually the 2006 agreement as well as the 2008 agreement. So obviously the case had some problems. We got into the case late. The lawyer before us withdrew after filing a notice for trial. We filed a motion for continuance because we did not feel that we could get prepared within the 6-week time frame that we had.
Jason, I understand all of that, and I'm not unsympathetic to it, but it's not the lawyer's case, it's the client's case.
That's true, sir.
And this case sat for years without anything having occurred, and that's really as much the responsibility of OMNI as it is the responsibility of the lawyers for OMNI. And so, yeah, when you get into a case that late, you know what you're getting into.
Sure.
And so the question is it an abuse of discretion for a trial judge who's had a case on his docket and he's got Supreme Court guidelines that govern how long cases should be, or the time frame for the disposition of cases, and he's got those mandates, and he's got this case on his docket that's been there for years. Is it an abuse of discretion for a trial judge to say enough's enough, we're going to move this case, we're going to get this case to resolution?
Sure. I think there was a burden upon Judge Harris in this instance to go ahead and get this case resolved. And it seemed as though he relied upon the fact that there had been so much time that had gone by. And I think that if you're going to hold the client responsible in this instance, that you've got to have a hearing where the client testifies that as to why he thought this case was being progressing properly as opposed to what it was, in fact, falling through the cracks. So I think...
But you could have had that in your motion.
Excuse me?
You could have put that information in the motion or attached an affidavit to the motion. I mean, that could have been presented to him.
Well, we did present it to him. We did present the fact that the case had fallen through the cracks, and it was not the responsibility of the business owner. It was the responsibility of the lawyer.
Sure it is. You know, I mean, you know, they know the case is out there. They know that there's nothing occurring in the case. They know that the case is languishing,
Right.
and they don't do anything about it. It is their responsibility.
Well, there were a number of cases that this lawyer had for this particular client, in excess of 10 cases. And there was a time period that...
Is that in the record?
It's not in the record,
Right,
no.
well,
So
then you can't argue it.
All right, then I won't touch upon that. But the reasons why that the client knew or understood that this case was being progressed improperly was raised in the actual motion itself.
Do you think it's an abuse of discretion that no judge would have done this? No judge would have taken that same position?
I think
Isn't that what your burden is on appeal, to
Yes, sir.
establish that it's an abuse, you know, that it was an abuse of discretion?
I think it was an abuse of discretion because...
I think no other judge, you know, no reasonable judge would have done that?
Well, I think in this instance, this judge should have allowed us to go forward with a continuance so that we can have the case tried on the merits. I think there's a strong public policy to have a case tried on the merits. He had a law firm that was there that was going to try the case to the end. All we were looking for was perhaps 60 days of continuance, and we could have had a trial on the merits. Instead, what we had was a truncated case where 3 witnesses testified.
And did you limit that request to 60 days?
Excuse me?
Did you limit the request for the continuance to 60 days?
I asked for a short, in the actual argument, I asked for 60 days.
Okay, so 60 days for the trial judge to put everything on hold, even though the trial judge has the dockets locked in place, probably well outside of the 60 days. You were asking the judge to move you from the front of the line back 60 days later to the front of the line as well to try the case. Isn't that unreasonable?
I didn't think it was unreasonable at the time based upon the court's trial docket, because the court's trial docket was filled with jury trials that went away. There was ample opportunity for us to have some time so that we could prepare the case for trial. You know, is it a situation where the court wanted to get it off his docket? I understand it. The court wanted to get it off his docket. But on the other hand, there are a lot of cases that go 5 years and get tried on the merits. The case that you had here just a few minutes ago went 7 years. And
how many days was this case slated to take up in trial?
it was initially requested to be 2 days,
Okay.
and it took 2 hours to try the case.
Let me talk just briefly about your argument on the conversion count. That could have, your argument is that that should have been a breach of contract?
Yes, sir.
Okay. And would the result have been altered?
I think the result,
If so, how?
I think the result would have been altered because the defenses that would have been raised to the breach of contract action would have been tied to the remedies set forth in the subscription agreement, which was rescission or specific performance. And in both those instances, rescission and specific performance, you have to act quickly to not sleep on your rights. So we would have had defenses associated with the delay in bringing any action pursuant to a breach of contract action for the subscription agreement.
Well, you wouldn't have gotten to keep the money. I mean, you know, presumably he would have either gotten the stock or gotten his money back under a breach of contract, right?
Well, he owed 50.
Well, that's a set-off, and you got to try your issue that he owed more than you'd paid him too much,
right?
And the judge said you didn't prove that you'd overpaid him.
Well,
So that's really a separate issue from the stock, which was presumably he gave you $50,000, and it was, you know, give me the stock or give me the money.
right.
I mean, that's really all that part of the deal was. Now, there was another part of the deal where he was getting quarterly draws, and then there was supposed to be an evening up.
Right.
And you tried that part, and didn't the judge say, well, you just didn't prove that he got too much?
Right, and I don't think that is borne out by the record. I think
I understand, but I guess I'm trying to figure out that why the issue of the stock isn't separate from the issue of whether you overpaid him on the draws. I mean, I understand how in the math, at the end of the day, there might be an evening up, but they're really two separate issues, aren't they?
I think they're separate issues, but they're made one issue by the fact that the agreement itself, the 2008 employment agreement, provided for this set-off if there was money owed to Dr. Ruiz.
But you went to trial on the 2006 agreement.
Well, that remains to be seen as to what really happened on the 2006 agreement, because the judge allowed the 2008 agreement to be introduced into evidence over my objection, and the 2008 agreement he found that
Your claim against them was predicated upon the 2006 agreement,
it
isn't it?
was predicated on 2006. However, the 2008 agreement was introduced by my opposing counsel and was part of the decision-making by the trial court. So, you know, from my perspective, the 2008 agreement should be used to mark the set-off.
Was the subscription agreement for the stock a separate contract
It was a separate contract from
from the employment agreement?
the employment agreement, but they would have all been drafted, they would have all been construed together because they were
No,
all
I understand,
executed
but
on the same
basically
day.
what that said was, if you pay $50,000 and you're still employed, you get the stock, right?
Right.
And he paid $50,000 and he didn't get the stock. And that $50,000 was specifically for the purpose of acquiring the stock.
Well, it was specifically for the purpose of acquiring the stock. However, it was not put into a specific account for,
Right. I mean, once you get money, presumably the corporation can do anything with it. But the specific, when he sent you the $50,000, your client understood that this was for the stock.
yes,
And it was paid at once
yes.
for one specific purpose.
It was for the specific purpose of the stock. But I don't think that gets you to the conversion standpoint under the case law. I think the case law that's cited by counsel shows that there has to be an obligation to preserve the money, keep it intact. And there was no obligation to keep the money intact. There certainly was no promise that, here, keep this $50,000 in escrow until you give me my stock. This money was put into the general operating funds of OMNI. So-
How do you...
You're in your rebuttal, just to,
Yes, sir.
I don't want to use your rebuttal time.
All right. Go ahead. I'll take
How
a
do you
little bit.
distinguish the cases where the creditor sends the debtor sends the creditor money and says, apply this to count X, and instead the creditor applies it to account Y, and the courts say that can be a conversion because there was specific instructions to apply it to a specific account, and you can't vary from those instructions?
Yeah, I don't think we had those facts with regard to the stock. I think that the stock was provided pursuant to the subscription agreement.
Right, but wasn't this, here's my $50,000 to be used to acquire the stock?
Sure.
And so when you applied it for some other purpose or didn't apply it at all, wasn't that contrary to essentially the debtor's instruction?
Well, if the debtor had given instructions, I would agree with you, but there were no instructions from the debtor.
Aren't his instructions contained in the subscription agreement? I send you $50K, you send me stock.
That's why it should be a breach of contract action and not a tort action.
I don't disagree that if I had lawyered the case, I would have filed a breach of contract, but I'm just trying to figure out if that strikes him out.
Okay. Thank you.
all right, thank you.
Your Honor, and may I please the court, Stephen Birch for the appellee, Dr. Francisco Ruiz. Details are important. The specifics are important in cases like this. And I think one of the biggest problems that the appellant's brief and their oral argument has is they kind of gloss over a lot of the specifics as to what happened. And I'll start getting into some of the specifics. And the first thing we touch on is liquidated damages. It's not just Section 27 that allows for both liquidated damages and actual damages. Section 8G, the restrictive covenant section, Section 8G provides, additionally, nothing herein shall be construed as prohibiting the corporation from pursuing any other remedies available herein for such breach or threatened breach of this Section 8, including the recovery of damages from doctor. So not only does Section 27 allow them the option to choose, do I want liquidated damages, do I want actual damages, Section 8, the restrictive covenant section, allows them the option to choose between actual damages and liquidated damages. And the Supreme Court's clear. If you have the ability to choose between actual and liquidated, the liquidated damages is a unenforceable penalty, and That's what the trial court found, and the trial court correctly found that. They argue severability, and I have the severability section here, and it's boilerplate severability argument, but it's that the invalid section is the one that should be struck from the contract. So if there's an invalid section,
Or unenforceable.
correct, and it would be the liquidated damages portion that is unenforceable. And so that is the one that should be struck. Instead of striking the entire contract, it's the liquidated damages portion that would have been struck. So I don't believe that severability gets them to where they're at. I don't believe that this idea that Section 8 standing alone gets them to where they're at. And I don't believe that that's the case either. I mean, the Section 27 is pretty clear that they have, in addition to any other rights, they have the ability, the remedy, that they reserve the right to have the remedy, any remedy the corporation may have at law or in equity under this agreement. So they've reserved themselves multiple times in this contract, clearly, plainly, there's no ambiguity, there's no inconsistency with the contract. They've given themselves the option, they drafted this, and they gave themselves the option to say, well, if our actual damages are less than $200,000, we'll take liquidated damages. If our actual damages are more than $200,000, we'll go after actual damages. They saved themselves that option, and that's what the Supreme Court doesn't want, and that's what most courts reviewing liquidated damages don't want. If you have the ability to say that your actual damages are less than the liquidated damages, you're never going to take actual damages. It's always going to be a penalty when you've saved yourself that option, and so that's what the Supreme Court in Lafimini was fighting against and held was prohibited.
This case had sat around for a long time.
That's correct.
With a lot of inactivity, lawyers not pushing the case at all. So when faced with a request for a 60-day continuance and an issue of amending, you've got the 2006 agreement, the 2008 agreement, why not just do it one time? What was the prejudice to your client in just giving another 60 days, amend the complaint, and do the discovery? It didn't appear like there was a whole mountain of discovery to do to get ready for litigation on both the 2006 and 2008 agreement, correct?
I would disagree with the amount of work necessary to get ready, and I think this is where the details and specifics come in. There were two motions to continue the case. The first motion to continue the case was about 6 weeks before the case went to trial docket. And in that motion, they said there wasn't, and I'd have to look, but I don't believe there was any request for, that they needed discovery. It was just that counsel needed time to get familiar with the file, and more importantly, and this was found by the trial court, it was not signed by the party in violation of Rule 1.460. And so there's no abuse of discretion at that point for the trial judge to say, I'm not granting this initial motion for continuance. And then there's another motion for continuance, and this is filed in conjunction. Initially, they file a motion to amend their complaint, to amend for actual damages on the 2006 agreement. They amend that motion, and they say, well, now we don't want actual damage on the 2006 agreement. We want an entirely new agreement, this 2008 agreement. And then they ask for continuance based on the time to look for discovery for actual damages. There's a lot of prejudice to our client for that. I would argue, and I did argue, that there's a statute of limitations problem. This is an entirely new contract. They're bringing a breach of contract claim, 7-8 years after the events at issue. So there's prejudice there. There's prejudice in that now there's a whole separate standard. He would have been, if you're suing under the 2008 agreement, there is, he's a shareholder. That he would have been a shareholder. It's a shareholder agreement. Restrictive covenants have different standards for that. Actual damages, up until for the past 5 years, no one had done discovery on actual damages. They're talking about getting experts. We would need to get similar experts. That's a lot of prejudice to my client to now assert a claim that they'd not asserted for 5 years. And and this is cited in my initial brief, and it was cited to the court. OMNI was aware back in 2011, 12, 13. There were all these other cases with similar contractual language going on, where they pursued a motion to dismiss for the liquidated damages clause, and they were being successful. OMNI was losing multiple cases I cited to. So they've known for years that liquidated damages may get kicked out in this case. It was an affirmative defense. We timely raised it. And they never took any action whatsoever to amend their complaint to say, well, in the alternative, we would like actual damages too. If they never did anything until days before trial. I mean, we're on the eve of trial at this point, and I don't believe it was abuse of discretion.
Well,
I
and
do
you
believe
were
there was
prepared-
massive
You were
prejudice.
prepared, weren't you? I would assume if you're a well-prepared trial lawyer, you're prepared to fight the introduction of any testimony or evidence concerning the 2008 agreement if you're on the eve of trial, correct?
I am, Your Honor.
Okay, so had you filed motions in limine to keep any mention of the 2008 agreement out?
Well,
of that trial?
and there's, again, with some of the details here, we actually wanted to use the 2008 agreement to certain extents as a defense, and we did, because the 2008 agreement, once it took effect, the idea that we needed to pay back any of these alleged overdraws goes away. You know, it supersedes that agreement. So we did want the 2008 agreement in, but we didn't want it. That's not their claim. We didn't want them to pursue a claim, and we fought that when they attempted to amend their motion. But we did want the 2008 agreement in evidence for different reasons, but not for their claim. They hadn't asserted any claim under the 2008 agreement, only the 2006 agreement. And I think, and this is another point that, that the trial court found, and I think it's important, is, this came out in discovery, there was there was a breach of the 2008 agreement. And there was a reason that, I don't know what it was, but I imagine there was a good reason why initial counsel pursued the 2006 agreement. They knew if they went under the 2008 agreement, they would be facing these ideas that, no, you breached the contract, it was anticipatorily repudiated. So they made a legal decision to go under the 2006 agreement. And then when they get new counsel, days before trial, they want to change the entire theory of the case and go for something else. And that's not proper. And that would have, and as the trial court found, that would have highly prejudiced my client. I think his words were, clearly allowing the substantial amendment to those pleadings on the eve of trial would cause significant prejudice to Ruiz. He heard all the evidence. We sat down and talked to him, and I can't see how he abused his discretion given all of the issues, all of the time. I don't see an abuse of discretion at all. You also talked about conversion. OMNI's asking you to reweigh facts. The trial court heard a lot of evidence. The transcripts in record, there's evidence in record. And he found that there was a conversion. He found that the money was specifically identifiable and that a conversion occurred. Opposing counsel cites to Belford for the idea that it has to be kept, in a certain deposit account. But that's not the case. The line from Belford is that's an or. Money is capable of identification where it is delivered at one time by one act and in one mass, or where the deposit is special and identical money is to be kept for the party making the deposit. That's an or. So if the money can be delivered at one time by one act and one mass, it's identifiable. And here it was delivered at one time in one act and in one mass, specifically a check for $50,000. So the trial court there's competent substantial evidence on the record for the trial court to have found that the money was specifically identifiable. And so a conversion, and there's for all the elements of conversion, but that seems to be the one they're specifically highlighting here.
And what occurred on the civil theft count?
I'm sorry, Your Honor?
You had brought a civil theft count.
We did, Your Honor.
And what did the trial judge do on that?
He found there was no civil theft. The intent wasn't there. The other claims, they're also asking you on the breach of contract, their breach of contract claim, and that's the same issue, that they're asking you to reweigh evidence and to kind of put it on us to prove a negative. They cite to some record evidence, well, look, here's a contract, here's where we said the amount was owed. But that's not the standard. They need to show that there was no competent substantial evidence that the trial court could have relied on to find, as he did, that there was no breach of contract on the part of Ruiz. And there were numerous facts. I don't know which ones precisely he relied on. He didn't enumerate why. But looking through the contracts, there was no contractual provision to support that he ever needed to repay this overage. I mean, this was his payment. Every quarter, they were supposed to adjust it. There's no requirement, especially once the 2008 agreement takes in on October 1st, that he has any obligation to repay this. So no breach at all. There was...
He gets a draw, doesn't do any work, and he's good. Under your theory, he has no obligation to the company.
If they have the right to adjust his draws, and I think if he terminates the agreement prior to its conclusion, they have the right to recover that money. But that's not what happened. On October 1st, 2008, the new 2008 agreement took over, and that's what prevented him from needing to pay back any of those. It superseded the agreement, the 2006 agreement. So there was no contractual obligation for him to pay. Even if he did owe back money, they came up with a new agreement and a new way to pay. And there was also conflicting evidence as to the amount of damages, if any. We cited to that in our answer brief. And there was also evidence that OMNI breached the 2006 agreement first, leaving him without any duty to repay. So there's lots of competent, substantial evidence on the record.
I think that the adjustment of the draws evidenced an intent that he is to be compensated for work done. Isn't that the intent of it?
It is the intent, Your Honor, but it's also based on the idea that they're going to both be working in good faith for the conceivable future, and that when they enter into new agreements, that they're going to honor those agreements. It's based on that implied covenant of good faith and fair dealings.
And then he admits that he violates the non-compete, correct?
I would, and that's one of the things I'd like to kind of close with. I don't believe he admits that. There's some issues. We went forward, given our position. The judge found that liquidated damages were an unenforceable penalty, but still allowed OMNI to proceed to try to prove a breach. I'm not sure, and found that they did prove a breach. But we also, given that there were no damages, we made trial strategy decisions to not present additional defenses, call additional witnesses to depositions, et cetera. And so while he did find that there was a breach, we would argue that if this went back, if this court said, no, liquidated damages are not an unenforceable penalty, or they should have been allowed to prove actual damages, we would ask that we relied on the trial court's ruling when we made our decision moving forward on the breach of contract or the breach of restrictive covenant. And we would ask that that entire claim be relitigated if it did come back, so that we could make appropriate showings. That they didn't seem prudent at the time to spend a lot of time and effort on a claim that at worst we have zero damages. And finally, one last thing is we filed a motion for attorney's fees. If this court finds that we prevail on this appeal, we believe we're entitled to attorney's fees, at least for the contractual claims. And no further questions. I have nothing else.
Thank you. All right, you got 2 minutes.
Okay, thank you. Let me come back to your point on the motion to amend and the motion for continuance. The motion to amend was such that we had for a number of weeks had the 2006 employment agreement as the agreement that we were suing under, and then right at the end of that period, we changed it out to the 2008 agreement. And the reason we changed it out to the 2008 agreement, and this is on the record at 1032, is because counsel at the summary judgment hearing brought up the fact that there was an integration clause in the 2008 employment agreement, and the 2008 employment agreement superseded the 2006 agreement. That had not been raised in any of the pleadings. The court went on to find that the 2006 agreement had in fact been superseded. That's in the order denying the motion to amend. So here's the court saying that we're not entitled to amend to the 2008 agreement, but when we get to trial, they put the 2008 agreement into evidence. And it seemed to us to be unfair over my objection to allow the 2008 agreement in. The 2008 agreement is essentially the same thing as the 2006 agreement. They are virtually identical. All that is different is the liquidated damages is $50,000 higher. So there was no prejudice because it was a new agreement. It was the same agreement, the same causes of action, the same parties, the same everything. And thus, the 2008 agreement came into evidence. So with that, Your Honor, I think that I'll conclude.
Thank you.
Thank you both.
All right, we'll be in recess.